I never thought a snowblower and a pair of cross-country skis would nearly bankrupt me. But that was before I met Patricia Hendricks from the Meadowbrook Estates Homeowners Association. It started on a crisp November morning in Boulder, Colorado. I was unloading my winter equipment from my truck after getting everything serviced and ready for the upcoming season. My garage was already packed with my woodworking tools, so I'd set up a neat storage area on the side of my house, tucked between the garage wall and the fence. It was barely visible from the street, organized with proper shelving, and covered with a weather-resistant tarp. I'd lived at 2847 Pinecrest Drive for 3 years without a single complaint. My name is Isaac Anderson, and I'm a 34-year-old software engineer who works from home. I bought this house specifically because it had enough space for my hobbies, and the neighborhood seemed quiet. The HOA fees were reasonable at $200 a quarter, and the rules seemed standard enough when I'd reviewed them before purchasing. Nothing prepared me for what was about to unfold. I was securing the last bungee cord on the tarp when I heard the clicking of heels on my driveway. I turned to see a woman in her late 40s marching toward me with a clipboard clutched against her chest like a shield. Her blonde hair was cut in that distinctive speak to the manager style, and her lips were pressed into a thin line of disapproval. "Excuse me," she said, her voice sharp enough to cut glass. "I'm Patricia Hendricks, president of the Meadowbrook Estates HOA board." "What exactly do you think you're doing?" I wiped my hands on my jeans and smiled, trying to be friendly. "Just storing my winter gear, getting ready for ski season." Her eyes narrowed as she looked at my carefully organized setup. "That is a direct violation of Section 12, subsection 4 of our community guidelines. No outdoor storage of recreational equipment is permitted." I felt my stomach drop. I read through the guidelines when I bought the house. I don't remember seeing anything about that. "Well, it's there," she snapped, flipping through papers on her clipboard. "And I'm issuing you a formal warning. This needs to be removed within 72 hours or you'll face a fine." "Can I at least see the specific section you're referring to?" I asked, keeping my voice calm. Patricia's face flushed red. "Are you questioning me? I've been the HOA president for 7 years. I know these rules inside and out. I'm not questioning your knowledge. I just want to understand exactly what I'm violating so I can fix it properly." She huffed, pulling out her phone and typing furiously. "I'll email you the relevant sections. 72 hours, Mr. Anderson, not a minute more." With that, she spun on her heel and marched back down my driveway, leaving me standing there confused and frustrated. I went inside and immediately pulled up the HOA guidelines I'd saved when I purchased the house. I spent the next 2 hours reading through every single section, subsection, and addendum. There was absolutely nothing about outdoor storage of recreational equipment. There were rules about leaving trash cans visible, parking RVs in driveways, and maintaining lawn height, but nothing about what I was doing. The email from Patricia arrived that evening. It was curt and condescending, with a scanned copy of what she claimed was Section 12, subsection 4. The problem was, the document looked different from my copy. The formatting was off and the language seemed newer. I checked the date on my original guidelines. They were from 2021 when I'd bought the house. Patricia's document was dated October 2024, just a month ago. I replied to her email politely, explaining that this appeared to be a new rule that hadn't been properly communicated to homeowners, and asked when it had been officially adopted and how residents had been notified. Her response came within minutes. "Ignorance of the rules is not an excuse. You have 72 hours. Over the next 3 days, I did some research. I talked to my neighbor, Ron, a retired accountant who'd lived in Meadowbrook Estates for 12 years. He was shocked when I told him about Patricia's visit. "That woman has been on a power trip ever since she became president," Ron said, shaking his head. "We were standing in his driveway and he gestured toward his own garage. See that?" He pointed to a small storage shed attached to the side of his house. "I've had that for 8 years. If there was a rule against outdoor storage, I'd have heard about it." "Did you get any notification about rule changes last month?" I asked. "Nothing. We usually get a newsletter when they update anything, but I haven't seen one in over a year." I thanked Ron and went home to make some calls. I contacted 3 other neighbors on my street. None of them had received any notification about rule changes. 2 of them had similar outdoor storage setups that had never been an issue. The 72 hours passed. On the 4th day, I received a certified letter from the HOA. Inside was a notice of fine. $500 for violating Section 12, subsection 4, with an additional $100 per week if the violation wasn't corrected. I felt my blood pressure rising as I read through the formal language, full of legal threats and demands for immediate compliance. I wasn't going to pay $500 for something that seemed completely manufactured. I decided to attend the next HOA board meeting, which, according to the newsletter I found online, was scheduled for the following Tuesday at 7 in the evening at the community center. That Tuesday, I arrived at the Meadowbrook Community Center at 6:45. The building was a modest single-story structure with a large meeting room that doubled as a space for community events. About 15 other residents were already there, chatting quietly in small groups. I recognized Ron and gave him a nod. At exactly 7, Patricia strode to the front of the room, followed by 3 other board members. A stern-looking man in his 60s named Donald, a nervous younger woman named Sarah, and another middle-aged woman named Barbara who seemed to be Patricia's right-hand person. "This meeting of the Meadowbrook Estates HOA board will now come to order," Patricia announced, rapping a gavel on the table. She went through standard business: approval of last meeting's minutes, treasurer's report, update on landscaping contracts. I waited patiently for the open forum section. "Any new business?" Patricia asked, clearly ready to wrap things up. I stood. "Yes, I'd like to address the board about a recent fine I received." Patricia's expression hardened. "State your name and address for the record." "Isaac Anderson, 2847 Pinecrest Drive." I was fined $500 for storing winter equipment on the side of my house. "I've reviewed the HOA guidelines from when I purchased my home, and there's no such rule. I'd like to understand when this rule was adopted and how homeowners were notified." The room had gone quiet. Patricia exchanged glances with Barbara before responding. "The rule has always been in place, Mr. Anderson. It's clearly stated in Section 12, subsection 4. "I have the guidelines from 2021 right here," I said, holding up my printed copy. "There's no such section." "The document you sent me appears to be from last month. Was there a vote to adopt new rules?" Donald, the older man, leaned forward. "Patricia, did we vote on amendments at the October meeting?" "This isn't an amendment," Patricia said quickly. "It's been in the rules all along. Mr. Anderson simply wasn't paying attention when he bought his house." "That's not true," I said firmly. "I read every page before closing. This rule doesn't exist in the official guidelines from 2021. "Your time is up," Patricia cut me off. "The fine stands. If you wish to dispute it, you'll need to follow the formal appeals process outlined in Section 22. "Which Section 22? I asked. "The one from 2021 or the one you apparently created last month?" Patricia's face turned crimson. "How dare you accuse this board of misconduct?" I'll have you removed from this meeting." Ron stood up from his seat. "Now hold on, Patricia. Isaac has a right to ask questions. I've been here 12 years and I don't remember any rule about outdoor storage. I've got a shed on the side of my house that's been there since 2015. "That's different," Barbara chimed in. "That's a permanent structure." "Actually, according to Section 9 of the Real Guidelines, permanent structures require prior approval, which I never got," Ron said. "So either you're enforcing rules selectively, or these new rules you're citing don't actually exist." The meeting dissolved into chaos. Several other residents started asking questions about other fines they'd received recently. Patricia kept banging her gavel and demanding order, but it was clear she'd lost control of the room. Finally, she declared the meeting adjourned and stormed out, with Barbara hurrying after her. Sarah, the nervous younger board member, approached me as people were filing out. "I'm sorry about that," she said quietly. "I only joined the board 6 months ago, and I've been confused about some of the things Patricia has been doing. I don't remember voting on any rule changes, but she always says they are already in place. You have access to the official HOA documents." I asked. She bit her lip. "Patricia keeps most of the records. She says it's easier that way since she's been president for so long, but I could try to look into it." "I'd appreciate that." "I'm not trying to cause trouble, but $500 is a lot of money for a rule that I don't think actually exists." Over the next week, things escalated quickly. I received another certified letter from the HOA, this time adding an additional $200 to my fine for failure to comply, and for disrupting a board meeting and showing disrespect to board members. The total was now $700, with the threat of legal action if I didn't pay within 14 days. I decided it was time to get professional help. I contacted a lawyer named Michael Chen who specialized in HOA disputes. His office was in downtown Boulder, in a modern building with a view of the Flatirons. Michael was in his early 40s, with sharp eyes and a calm demeanor that immediately put me at ease. I explained the entire situation, showing him both versions of the guidelines and all the correspondence from Patricia. He listened carefully, taking notes and occasionally asking clarifying questions. "This is interesting," Michael said when I finished. "HOAs do have the authority to create and enforce rules, but there's a legal process they have to follow. Rules typically need to be voted on by the board, properly documented, and residents need to be given adequate notice, usually 30 to 60 days before enforcement begins. So even if they did create this rule last month, they can't fine me for it yet?" I asked. "Correct. And more importantly, if they're claiming the rule has always existed when it clearly hasn't, that's a serious problem. It could constitute fraud." He flipped through the documents again. "I'm also concerned about this escalating fine structure. Most HOA governing documents specify maximum fine amounts and require specific procedures before imposing them. Have you received any formal hearing notice?" "No, just the letters demanding payment." "That's another violation of proper procedure. Most state laws require HOAs to provide owners with an opportunity for a hearing before imposing fines." He leaned back in his chair. "Mr. Anderson, I think you have a strong case here. The question is how you want to proceed. We could pay the fine under protest and fight for reimbursement, or we could challenge this directly and refuse to pay." "What happens if I refuse to pay?" "They'll likely escalate. They could place a lien on your property, though that requires additional legal steps. Or they might sue you directly in small claims court, but honestly, that might be the best outcome for us." "How is being sued the best outcome?" I asked, confused. Michael smiled. "Because then we get discovery. We can subpoena all their records, meeting minutes, financial documents. If they've been doing this to other homeowners, if there's a pattern of harassment or fraudulent rule enforcement, it all comes out. And if we're in court, you have full due process protections. I thought about it. $700 was a lot of money, but it was the principle that really bothered me. I couldn't let Patricia bully me into paying for something I hadn't done wrong. Let's fight it, I decided. Michael nodded approvingly. I'll draft a response to their demand letter. We'll formally dispute the fine and request a proper hearing with full documentation of when and how this rule was adopted. Let's see what they do. The response letter went out the next day. It was polite but firm, outlining all the procedural failures and demanding proof that the rule had been properly adopted and that I had been given adequate notice. It also pointed out that I had a right to a hearing before any fines could be imposed. Patricia's response came within 48 hours, and it was venomous. The letter accused me of frivolous legal tactics, warned that I was racking up additional fines for non-compliance, and stated that the HOA would pursue all available legal remedies, including placing a lien on my property and reporting the debt to credit agencies. Empty threats, Michael said when I forwarded him the email. They can't just place a lien without following proper procedures and reporting to credit agencies. That would open them up to significant liability if the debt isn't legitimate. She's trying to scare you into backing down. But Patricia wasn't done. Over the next 2 weeks, I received 3 more certified letters, each one more threatening than the last. The fine had now ballooned to $1,200. She claimed I was now in violation of multiple sections of the HOA rules, including maintaining an eyesore and diminishing property values for neighboring homes. Then things got weird. I started receiving complaints about other supposed violations. My lawn was allegedly a 1/4 inch too long. I had supposedly left my trash cans visible from the street for more than 12 hours after pickup. Something I knew for a fact wasn't true, because I had a Ring doorbell camera that showed exactly when I brought my cans in. My house numbers were allegedly the wrong size, even though they were the same numbers that had been there when I bought the house. It became clear that Patricia was targeting me specifically. Ron confirmed it when he told me that she'd been asking other neighbors if they'd seen me commit any violations. She was apparently going around with a measuring tape and clipboard, looking for anything she could cite me for. She did the same thing to the Millers 3 years ago, Ron told me over coffee one morning. They had a dispute about their fence height, and Patricia made their lives hell for 6 months. They ended up selling and moving away. What happened with the fence? I asked. Turned out Patricia was wrong about the rule. Their fence was perfectly compliant, but the stress of dealing with constant harassment and fines just wore them down. That's her strategy. She figures most people will eventually give up and either pay or leave. I'm not going anywhere, I said. Michael filed a formal complaint with the Colorado Division of Real Estate, which oversees HOA disputes. We documented every letter, every fine, every alleged violation, and submitted a detailed timeline of events. We also filed a motion in Boulder County Court to dispute the fines and request a formal hearing. The court date was set for February 15th, giving us about 6 weeks to prepare. Michael immediately filed for discovery, requesting all HOA documents, meeting minutes, financial records, and any correspondence related to rule changes or enforcement actions from the past 3 years. Patricia fought the discovery request. Her lawyer, a bored-looking man named Richard Peters, filed a motion to quash, arguing that internal HOA documents were privileged. But the judge, A no-nonsense woman named Judge Elizabeth Morrison wasn't having it. "This is a civil dispute about the enforcement of HOA rules," Judge Morrison said during a preliminary hearing I attended with Michael. "The plaintiff has a right to examine the documents that supposedly justify these fines. Motion to quash is denied. The HOA will produce all requested documents within 30 days. Patricia looked like she was about to explode. She was sitting in the front row of the courtroom, and I could see her whispering furiously to Richard Peters. Barbara was next to her, equally red-faced. The produced documents were illuminating. When they finally arrived, 3 days before the deadline, Michael and I spent an entire evening going through them at his office. We ordered pizza and spread everything out on his conference room table. "This is remarkable," Michael said, holding up a sheet of paper. "Look at this meeting minute from October 2024. It says the board voted to clarify existing language in Section 12 regarding outdoor storage. But there's no actual language provided, no specifics about what was clarified, and most importantly, look at the attendance record." I leaned over to see. Only 2 board members present, Patricia and Barbara. Where were Donald and Sarah? Exactly. According to their own bylaws, they need at least 3 members for a quorum. This vote wasn't even valid. He pulled out another document. And here's the really interesting part. I found the original HOA guidelines filed with the county when Meadowbrook Estates was established in 2006. Section 12 is about architectural modifications. It has 4 subsections, all dealing with things like paint colors and roof materials. There's nothing about outdoor storage anywhere. "So she just made it up," I said, feeling a mixture of vindication and anger. "It appears so." But wait, there's more. Michael handed me a spreadsheet. "These are the HOA financial records for the past 3 years. Notice anything interesting?" I scanned the columns. There are a lot of fines collected, like a lot. $68,000 in fines over 3 years to be exact. For a community of only 45 houses, that's extraordinary. The average HOA fine collection should be maybe a few $1,000s a year for actual violations like seriously overgrown lawns or unauthorized construction. This suggests they're fining people at a rate of over $1,000 per household per year. "That can't be normal," I said. "It's not. And look at this." He pointed to another section of the records. "Patricia receives an annual stipend as HOA president. That's not unusual. What is unusual is that her stipend increased from $2,000 a year to $8,000 a year in 2022. That increase was approved at a meeting where only she and Barbara were present. Is that legal? Doubtful. Most HOA bylaws require significant financial decisions to be approved by a full board vote, and often by the membership as a whole for amounts over a certain threshold." Michael sat back in his chair. "I think what we're looking at here is a pattern of abuse. Patricia has essentially been running this HOA as her personal fiefdom, making up rules, imposing fines, and enriching herself in the process." "What do we do with this?" I asked. "We present it all to Judge Morrison. And I think we should also consider filing a countersuit for harassment and abuse of process. What Patricia has done to you, and apparently to many other homeowners, goes beyond a simple dispute about HOA rules. This is systematic harassment designed to extract money from residents." The following week, Michael filed an amended complaint. In addition to disputing the original fine, we were now suing Patricia personally and the HOA as an entity for harassment, abuse of process, intentional infliction of emotional distress, and fraud. We also sent copies of our findings to every homeowner in Meadowbrook Estates, along with a notice that we were organizing a special meeting to call for a vote to remove Patricia from the board. The special meeting was held on a Saturday morning in late January. The community center was packed. Nearly every household had at least one representative there, and the energy in the room was electric. People were angry. Once one person spoke up about the fines they'd received, others chimed in with their own stories. A woman named Jennifer described how she'd been fined $800 for having the wrong shade of white paint on her trim, even though she'd matched it exactly to the approved color samples. A retired couple, the Johnsons, talked about being fined repeatedly for their lawn being too short, too long, or having brown patches, despite hiring a professional landscaping service. Another resident, Tom, showed photos of his driveway, which Patricia had claimed was stained and unsightly, demanding he repave it at a cost of over $6,000. The photos showed a perfectly normal concrete driveway with minor wear consistent with its age. The stories went on for over an hour. It became clear that Patricia had been terrorizing the entire community, targeting anyone who questioned her authority or who she simply decided to go after. The fines were often arbitrary and always excessive. When it came time to vote, the result was overwhelming. 38 of the 45 households voted to remove Patricia from the board immediately. Barbara was also removed. Donald and Sarah, the other two board members, were kept on pending a review of their involvement. A temporary board was appointed to oversee HOA affairs until proper elections could be held. Patricia stood up as the votes were tallied, her face purple with rage. "This is illegal. You can't just remove me. I'll sue every single one of you." Actually, according to your own bylaws, a special meeting can be called by petition of at least 20% of homeowners, and board members can be removed by a majority vote, said a lawyer named Frank who lived on Maple Street and had volunteered to moderate the meeting. "This vote is entirely proper and legal. You're done, Patricia." She stormed out with Barbara trailing behind her. As they left, someone in the crowd started clapping, and soon the entire room erupted in applause. But Patricia wasn't going to go quietly. 2 days later, she filed her own lawsuit against me personally, claiming defamation and intentional interference with her position as HOA president. She was seeking $50,000 in damages and demanding that all the documents we distributed be retracted. "This is called a slap suit," Michael explained when I showed him the filing. "Strategic lawsuit against public participation. It's designed to intimidate you into backing down by burying you in legal costs. Fortunately, Colorado has strong anti-slap laws. We can get this dismissed and potentially recover attorney's fees." The original hearing date of February 15th finally arrived. Judge Morrison's courtroom was modern and surprisingly comfortable, with large windows that let in natural light. I sat next to Michael at the plaintiff's table, while Patricia and Richard Peters sat across the aisle. The new temporary HOA board had sent a representative, a sensible woman named Carol who'd been elected as interim president, to observe and provide testimony if needed. Judge Morrison entered, and we all stood. She settled into her chair and reviewed her notes for a moment before addressing the courtroom. "We're here today regarding multiple related matters," she began. "The original dispute over HOA fines imposed on Mr. Isaac Anderson, Mr. Anderson's countersuit against the HOA and Mrs. Patricia Hendricks personally, and Mrs. Hendricks' defamation suit against Mr. Anderson. Let's start with the core issue, the validity of the fines imposed on Mr. Anderson. Mr. Chen, please proceed." Michael stood and presented our case methodically. He walked through the timeline, showed the two different versions of the HOA guidelines, and presented the meeting minutes that showed the supposed rule change had been voted on without proper quorum. He introduced the original 2006 guidelines and demonstrated that Section 12 had never contained any language about outdoor storage of recreational equipment. Richard Peters, Patricia's lawyer, tried to argue that the rule was a clarification of existing authority the HOA had over maintaining property appearance. But when Judge Morrison asked him to point to specific language in the original documents that gave them that authority, he couldn't do it. Your Honor, the HOA has broad authority to regulate matters affecting property values and community aesthetics, Richard said, sounding less confident than he probably wanted to. Broad authority still has to be grounded in specific language in the governing documents, Judge Morrison responded. I've reviewed the original HOA covenants and bylaws. There's nothing that gives the board authority to regulate outdoor storage of properly maintained equipment that isn't visible from the street. And Mr. Anderson's equipment was behind a fence, according to the photos. It was visible from certain angles, Richard argued weakly. Judge Morrison looked at him over her glasses. Mr. Peters, I think we both know this is a losing argument. Let's move on. Mr. Chen, what evidence do you have regarding the harassment claim? Michael presented the timeline of escalating fines, the multiple letters threatening legal action, and the additional manufactured violations that Patricia had tried to impose. He also introduced testimony from Ron, Jennifer, and several other Meadowbrook Estates residents about their own experiences. By the time Ron finished describing how Patricia had harassed the Miller family until they moved away, Judge Morrison's expression had shifted from neutral to actively disapproving. Mrs. Hendricks, the judge said, looking directly at Patricia. Did you personally inspect Mr. Anderson's property multiple times looking for violations after he disputed the original fine? Patricia stood, her voice defiant. I was doing my job as HOA president. It's my responsibility to ensure all residents comply with our rules. Did you conduct similar, frequent inspections of other properties? Patricia hesitated. I inspect properties as needed. That's not what I asked. Did you conduct the same level of scrutiny on other properties as you did on Mr. Anderson's? Some residents require more oversight than others, Patricia said stiffly. I'll take that as a no. Judge Morrison made some notes. Mr. Peters, do you have any defense to present regarding the harassment claim? Richard stood, looking uncomfortable. Your Honor, Mrs. Hendricks was acting in her official capacity as HOA president. She has qualified immunity for actions taken in good faith while performing her duties. Qualified immunity doesn't apply when someone is acting outside the scope of their authority or engaging in harassment, Judge Morrison said. Making up rules, imposing invalid fines, and then retaliating against someone for challenging those fines is not acting in good faith. The hearing continued for another 2 hours. Michael presented the financial records showing the pattern of excessive fines and Patricia's suspicious salary increase. We showed the documentation of the community vote removing her from the board. Finally, Michael addressed Patricia's defamation suit against me. Your Honor, this suit is clearly retaliatory and meets the definition of a SLAPP suit under Colorado law. Mr. Anderson made truthful statements based on documentary evidence and shared them with fellow community members who had a legitimate interest in knowing how their HOA was being run. Truth is an absolute defense to defamation, and there's no defamation in sharing factual documents. Judge Morrison nodded. I agree. Mrs. Hendricks, your defamation suit is dismissed with prejudice. You're fortunate I'm not sanctioning you for filing a frivolous lawsuit. Patricia's face went white, then red. "This is outrageous. He destroyed my reputation." "You destroyed your own reputation, Mrs. Hendricks," Judge Morrison said sharply. "Now sit down." After reviewing all the evidence and hearing brief closing arguments, Judge Morrison took a short recess to consider her ruling. When she returned 30 minutes later, I could tell by her expression that things were not going to go well for Patricia. "I've reviewed all the evidence and testimony presented today," Judge Morrison began. "This is one of the more egregious cases of HOA abuse I've encountered in my years on the bench. Mrs. Hendricks, you systematically violated the rights of the homeowners you were supposed to serve. You manufactured rules, imposed invalid fines, and when challenged, you engaged in what can only be described as harassment and retaliation." She shuffled her papers and continued. "The fines imposed on Mr. Anderson are dismissed in their entirety. Not only were they based on a non-existent rule, but they were imposed without proper procedure. The HOA failed to provide adequate notice, failed to offer a hearing, and failed to follow its own bylaws regarding the adoption of new rules." Patricia's lawyer started to stand, but Judge Morrison held up her hand. "I'm not finished. Regarding Mr. Anderson's countersuit, I find in his favor on all counts. Mrs. Hendricks, you are personally liable for harassment and abuse of process. You intentionally inflicted emotional distress on Mr. Anderson through your campaign of retaliation after he challenged your authority. The court awards Mr. Anderson compensatory damages in the amount of $5,000 for his time, stress, and attorney's fees to date. Additionally, I'm awarding punitive damages of $15,000. The purpose of punitive damages is to punish wrongful conduct and deter future similar behavior. Your conduct, Mrs. Hendricks, was egregious enough to warrant a significant punishment." Patricia jumped to her feet. "I don't have $20,000. Then you'll need to work out a payment plan with Mr. Anderson's attorney," Judge Morrison said coldly. "Furthermore, I'm ordering you to pay an additional fine of $2,500 to the court for abuse of process. Your frivolous defamation suit wasted judicial resources and was clearly filed in bad faith." "This is insane," Patricia shouted. "He's the one who should be punished. He turned the entire community against me. Mrs. Hendricks, you need to control yourself or I'll hold you in contempt," Judge Morrison warned. "You turned the community against yourself through your own actions. Mr. Anderson simply revealed what you were doing." The judge turned to Carol, the interim HOA president. "I'm also issuing an order that the Meadowbrook Estates HOA shall pay Mr. Anderson's remaining attorney's fees, estimated at $8,000. The HOA as an entity is responsible for the actions taken in its name, even if those actions were unauthorized. The HOA may seek reimbursement from Mrs. Hendricks if it chooses." Carol nodded. "Understood, Your Honor. The new board has already voted to revoke all fines imposed during Mrs. Hendricks' tenure that were based on questionable rule interpretations. We're committed to reforming how the HOA operates." "Good," Judge Morrison said. "I'm going to add one more thing to this order. Mrs. Hendricks, you are permanently barred from serving on the Meadowbrook Estates HOA board or any other HOA board in Boulder County. This order will be noted in the county records. You can't do that." Patricia protested. "I just did. And if you continue to interrupt these proceedings, I will hold you in contempt, which will result in additional fines and possibly jail time. Do you understand?" Patricia's mouth opened and closed like a fish, but she finally sat down, her face a mask of fury and humiliation. Judge Morrison concluded the hearing and dismissed us. As we walked out of the courtroom, I felt like a weight had been lifted off my shoulders. Michael was grinning. "That went better than I could have hoped," he said. "Judge Morrison doesn't mess around. $22,500 in damages and fees is a serious penalty." "You think she'll actually pay?" I asked. "She'll have to unless she wants wage garnishment or a lien on her own property. The court's judgment is enforceable. She could appeal, but she has no grounds. Judge Morrison's ruling was thorough and well supported by the evidence." As we stood outside the courthouse, Patricia stormed past us, with Richard Peters trying to keep up with her. She shot me a look of pure hatred but didn't say anything. "You haven't seen the last of me," she hissed as she walked by. "Mrs. Hendricks, I strongly advise you not to make threats," Michael called after her. "Any further harassment of my client will result in additional legal action." She kept walking, and I watched her disappear into the parking lot. I felt a brief moment of sympathy for her, watching her world collapse, but then I remembered all the families she'd harassed, all the money she'd extracted through fake fines, and the sympathy evaporated. Over the next few weeks. Things slowly returned to normal. The new HOA board sent out a newsletter apologizing for Patricia's conduct and outlining reforms they were implementing. They hired a professional management company to handle day-to-day HOA operations and ensure compliance with proper procedures. They also conducted a review of all fines imposed in the previous 3 years and refunded money to residents who'd been charged improperly. I got a check from the HOA for the $8,000 in attorney's fees, along with a personal note from Carol apologizing for what I'd been put through. Getting that money back was nice, but honestly, the vindication meant more to me than the cash. Patricia made one payment of $500 toward her judgment, then stopped paying. Michael filed for wage garnishment, and we discovered that she'd been working as an office manager for a dental practice. Part of her paycheck started being diverted to pay off the judgment. At the rate it was going, it would take her about 2 years to pay off the full amount, assuming she kept her job. About a month after the court ruling, something unexpected happened. I got a call from an investigator with the Colorado Division of Real Estate, a man named James Crawford. He wanted to meet with me to discuss Patricia's conduct as HOA president. We met at a coffee shop in Boulder. James was a methodical guy in his mid-50s who took detailed notes as I walked him through everything that had happened. He was particularly interested in the financial records Michael had obtained through discovery. "We've been receiving complaints about HOA abuse across the state," James explained. "Your case caught our attention because of how well documented it was. We're investigating whether Mrs. Hendricks violated state laws regarding HOA governance." "What kind of violations are we talking about?" I asked. "Potentially fraud, embezzlement if she personally benefited from the improper fines, and violations of fiduciary duty. The fact that she increased her own salary without proper authorization is particularly concerning. We're also looking at whether this might constitute racketeering if there was a systematic scheme to extract money from homeowners through fraudulent fines." "That sounds serious," I said. "It is." "We're also looking at Barbara Thompson, the other board member who seemed to be working with Mrs. Hendricks. If this goes where I think it might go, we'll be referring the case to the district attorney's office for potential criminal charges." I left the meeting feeling somewhat dazed. I just wanted to store my winter equipment and defend myself against an unjust fine. Now there might be criminal charges against Patricia. 2 months later, in early May, I got a call from James Crawford with an update. The Division of Real Estate had completed its investigation and referred the case to the Boulder County District Attorney. They had found evidence that Patricia had collected over $68,000 in fines over 3 years, with at least 45,000 of that being based on either non-existent rules or improperly imposed penalties. They also discovered that Patricia had funneled some of the fine money into a separate account that she controlled, claiming it was a reserve fund for community projects. In reality, she'd used about $12,000 from that account for personal expenses, including a vacation to Hawaii and payments on her car lease. The DA is filing charges for theft, embezzlement, and fraud, James told me. Barbara Thompson is being charged as an accessory. They're looking at multiple felony counts. I can't believe this, I said. I mean, I knew she was abusing her power, but I didn't think she was actually stealing. It's more common than you'd think with HOAs, James said. When there's minimal oversight and someone has that much control, it's easy for things to go off the rails. Your case helped us establish a pattern that will hopefully lead to reforms in how HOAs are monitored. The criminal case moved slowly through the system. Patricia hired a criminal defense attorney and initially tried to fight the charges, claiming everything she'd done was within her authority as HOA president. But the evidence was overwhelming. The financial records showed clear misappropriation of funds, and the testimony from dozens of homeowners established a pattern of abuse. In August, Patricia's lawyer worked out a plea deal. She pleaded guilty to 1 count of felony theft and 2 counts of fraud. In exchange for her guilty plea, the other charges were dropped, and she received a sentence of 3 years of supervised probation, 6 months of home detention with electronic monitoring, and full restitution of the $12,000 she'd stolen. She was also permanently barred from serving on any HOA board in Colorado and had to complete 100 hours of community service. Barbara Thompson pleaded guilty to being an accessory and received 2 years of probation and a $5,000 fine. I attended Patricia's sentencing hearing. She stood before Judge William Tucker in the criminal court, looking diminished and defeated. The confidence and arrogance were gone, replaced by a woman who'd lost everything: her position, her reputation, her freedom, and a significant amount of money. Mrs. Hendricks, you were in a position of trust, Judge Tucker said during sentencing. Homeowners relied on you to manage their community association fairly and honestly. Instead, you abused that trust for personal gain and to satisfy what appears to be a need for power and control. Your actions harmed dozens of families and eroded trust in community governance. Patricia's voice was barely audible when she apologized. I'm sorry for what I did. I never meant for things to go this far. I just wanted to maintain standards in our community. Maintaining standards doesn't require making up rules, imposing invalid fines, and stealing from the community treasury, Judge Tucker said firmly. I hope you use your probation period to reflect on your actions and make amends. As I left the courthouse that day, I ran into Ron in the parking lot. He'd also attended the sentencing. Never thought it would end up like this, Ron said, shaking his head. I mean, I knew she was on a power trip, but actual criminal charges. She crossed a line, I said. A lot of lines, actually. Well, the neighborhood is better off now. Carol and the new board are doing a great job. They actually care about the community instead of using it as their personal kingdom. Ron paused, then grinned. By the way, I noticed you still have your winter equipment stored on the side of your house. I laughed. Yeah, and nobody said a word about it. Funny how that works. Life in Meadowbrook Estates gradually returned to normal. The professional management company the new board hired handled routine matters efficiently and fairly. Fines, when they were imposed, were for legitimate violations and were reasonable in amount. The community newsletter started focusing on actual community events rather than rule enforcement and threats. In September, almost a year after the whole ordeal started, the HOA held its annual meeting to elect a permanent board. The turnout was the highest in the community's history. People actually cared about HOA governance now, having seen firsthand what could go wrong when residents weren't paying attention. Carol was elected president in a landslide. Ron agreed to serve as treasurer, bringing his accounting expertise to bear. Several other engaged residents joined the board, including Jennifer and Tom, who'd both been targets of Patricia's harassment campaign. At that meeting, Carol made a point of publicly thanking me. Isaac's willingness to stand up to an unjust fine and see it through, even when it would have been easier to just pay and move on, saved this community. He exposed a pattern of abuse that had been going on for years, and that would have continued if someone hadn't finally said enough. The room applauded, and I felt my face flush with embarrassment. I hadn't been trying to be a hero. I'd just been defending my right to store my winter equipment on my own property. After the meeting, several neighbors approached me to share their own stories and thank me personally. It turned out Patricia had targeted far more people than I'd realized. Some had paid unjust fines rather than fight. Others had altered their properties unnecessarily to comply with made-up rules. A few had even considered moving, just like the Miller family had done. "You saved us thousands of dollars," one elderly couple told me. "We were about to have our perfectly good driveway repaved because Patricia said it was required. Now we know it wasn't." As autumn arrived and the leaves began to change colors across Boulder, I found myself reflecting on the whole experience. It had been stressful, expensive despite ultimately recovering my costs, and time-consuming. But it had also been worth it. I'd learned important lessons about standing up for what's right, about not backing down when someone tries to bully you, and about the importance of community members staying engaged with their HOA rather than treating it as something that just happens in the background. My winter equipment remained exactly where it had been the day Patricia first confronted me about it. The snowblower, the skis, the winter camping gear, all neatly organized under a weather-resistant tarp between my garage and fence. Every time I looked at it, I smiled a little, remembering how something so simple had led to such a complex and ultimately important battle. The best part was the sense of community that had emerged from the whole mess. Neighbors who had barely spoken to each other before now regularly chatted at the mailboxes or organized informal gatherings. We'd been through something together, and it had brought us closer. Ron and I started a tradition of having coffee every Saturday morning, usually joined by 3 or 4 other neighbors. We'd talk about everything except HOA politics, which we'd all had more than enough of. We discussed sports, shared recipes, complained about work, and helped each other with home projects. One Saturday in late October, as the first snow of the season was starting to fall, Ron raised his coffee mug in a toast. To Isaac, for being too stubborn to let a petty tyrant win. Everyone laughed and clinked their mugs together. "I prefer to think of it as being principled," I said with a grin. "Potato, potato," Ron replied. "Either way, you did good." As winter set in for real, and I pulled out my snowblower for the first time that season, I couldn't help but think about how different things might have been. If I just moved my equipment into an already overcrowded garage, or paid the initial fine to avoid conflict, Patricia would still be running the HOA like her personal fiefdom. More families would have been harassed, more money would have been extracted through fraudulent fines, and the community would have continued suffering under her rule. Sometimes standing up for yourself means standing up for everyone. Sometimes refusing to accept injustice, even over something as minor as where you store your winter equipment, can expose corruption and lead to real change. I never did get an apology directly from Patricia, but I didn't need one. The court's ruling, the criminal conviction, and the reforms in Meadowbrook Estates were vindication enough. Justice had been served, the community was better off, and I could store my winter equipment wherever I wanted. The following spring, Carol approached me about joining the HOA board. I politely declined. I'd had enough of HOA politics to last a lifetime, but I did agree to serve on a newly formed oversight committee that would review any proposed rule changes and ensure the board was following proper procedures. It was a small time commitment that would help prevent another Patricia situation from ever developing. As I write this, sitting in my home office with a view of the Colorado mountains, it's been 18 months since Patricia first confronted me in my driveway. She completed her home detention and is still on probation, working to pay off her restitution. I heard through the neighborhood grapevine that she moved out of Meadowbrook Estates, unable to face the neighbors she'd wronged. Barbara also moved away, though her involvement had been much less than Patricia's, and most residents were willing to forgive her once she apologized and made her own restitution payments. The new HOA board has been efficient, fair, and transparent. They post all meeting minutes online, provide advance notice of any proposed rule changes, and actively solicit input from residents. Fine collections have dropped to less than $2,000 a year, almost all for legitimate violations like repeatedly leaving trash cans out or having genuinely overgrown lawns that residents failed to address, despite multiple friendly reminders. Property values in Meadowbrook Estates have actually increased since Patricia's removal, contrary to her predictions that challenging her authority would harm the community. Turns out that having a fair and functional HOA is more valuable than having a dictator who harasses residents. My winter equipment still sits in its spot by the garage, a daily reminder that sometimes the smallest things can lead to the biggest changes. The snowblower that started it all has served me well through 2 winters now, and every time I use it to clear my driveway, I think about the journey it inadvertently set in motion. I've been contacted by a few other homeowners in different communities dealing with similar HOA issues, asking for advice based on my experience. I always tell them the same thing. Document everything, know your rights, don't be afraid to stand up to bullies, and find a good lawyer who specializes in HOA disputes. Most HOA boards are well-intentioned volunteers trying to maintain their communities. But occasionally, someone like Patricia comes along who sees an HOA as an opportunity for power and profit. When that happens, it's up to the homeowners to take action. It's not easy and it's rarely quick, but it's necessary. The legal system worked the way it was supposed to in my case. Judge Morrison saw through Patricia's lies and manipulation. The Division of Real Estate and the District Attorney's Office took homeowner abuse seriously. The community came together to remove a corrupt board and implement real reforms. It gives me hope that even when systems are corrupted by bad actors, there are mechanisms to expose and correct that corruption. Looking back, I'm grateful for several things. I'm grateful that I trusted my instincts when something felt wrong about Patricia's fine. I'm grateful that I had the resources to hire a lawyer rather than being forced to pay an unjust fine I couldn't afford to fight. I'm grateful for neighbors like Ron who supported me and shared their own experiences. And I'm grateful for legal professionals like Michael Chen and investigators like James Crawford who took my case seriously. Most of all, I'm grateful that I didn't just accept the injustice and move on. It would have been easier in the short term to pay $500 and relocate my winter equipment. But easier isn't always better. Sometimes you have to take the hard road, not just for yourself, but for everyone who comes after you. As winter approaches again and I prepare my equipment for another season, I do so with a sense of satisfaction. My simple act of storing a snowblower and some skis led to exposing corruption, reforming an HOA, criminal convictions, and a stronger sense of community in Meadowbrook Estates. Not bad for some winter equipment. The whole experience taught me that you never know where standing up for yourself might lead. What started as a dispute over 50 square feet of storage space became a referendum on HOA governance, a legal battle that established important precedents, and ultimately a criminal case that will hopefully deter similar abuse in other communities. Every time I see my winter equipment neatly stored on the side of my house, properly maintained and ready for use, I'm reminded that justice sometimes comes from the most unexpected places. Sometimes all it takes is one person saying no to injustice, even when that injustice seems small and personal. Because small injustices left unchecked become big injustices, and personal abuses become community-wide corruption. Patricia probably thought she was intimidating just another homeowner who would eventually cave to her demands. She didn't count on running into someone stubborn enough to fight back, smart enough to document everything, and lucky enough to find good legal representation. Her downfall wasn't inevitable, but it became so the moment she decided to escalate rather than back down when challenged. I hope Patricia learned something from the experience, though I have my doubts. Some people are so convinced of their own righteousness that they never truly understand when they've crossed ethical and legal lines. But whether she learned or not, others certainly did. The homeowners of Meadowbrook Estates learned to stay engaged with their HOA. The Division of Real Estate learned to take HOA complaints seriously. And hopefully, other HOA board members across Colorado and beyond learned that abusing your position comes with real consequences. As for me, I learned that I'm more capable than I thought of standing up to intimidation and seeing a fight through to the end. I learned the importance of good documentation and expert legal advice. And I learned that communities are stronger when neighbors support each other against common threats, whether those threats come from outside or from within their own governance structures. The snow is falling harder now, and I should probably get out there with my snowblower soon. But first, I'm going to finish this coffee and enjoy the view of the mountains, because I can. Because this is my house, on my property, in a community that now respects homeowners' rights rather than trampling them, and my winter equipment. It's right where it belongs, stored safely and legally on the side of my house, ready for another season. No fines, no harassment, no drama, just the way it should have been from the beginning,